Good evening, everyone. Sorry for the disturbances that occurred in the last two classes because I was out of station, so there was network issues there. Okay, but from today onwards, there will be the classes will be running smoothly. Okay, so in the last class, we were discussing about some differences between partnership and other kind of organizations, right? We have started Partnership Act 1932. We are in the mid of that act. Today, we'll be discussing differences between partnership and other kind of businesses. Secondly, we'll be discussing about what are the kinds of partners, what are the types of partners, and lastly we'll be discussing about the registration of the partnership firm. Okay, so these three topics we'll be discussing today. So open page number 183 of your modules. Page number 183 of your modules. Okay, so firstly, we'll be discussing difference between an Hindu undivided family and a partnership firm. Okay, so when we talk about partnership firm, the first and foremost basic difference between partnership firm and Hindu undivided family is the provisions, the criteria, the settlement, etc. Everything, each and every problem of a partnership business is governed by Indian Partnership Act 1932. But on the other hand, the provisions of Hindu undivided families are governed by Hindu law. They are governed by Hindu law. A separate Hindu law is made in which all the provisions regarding a Hindu undivided family are governed. Second difference is a partner is appointed by mutual consent of all the other partners, or a partnership is formed out of contract. Okay, so nobody can be appointed like that only. But when we talk about Hindu undivided family, a person by birth becomes the member of the HUF. Okay. So second difference is partner is not appointed by birth, partner is appointed by the remaining partners by mutual consent. But in HUF, a member is appointed by birth. Third, any male, female, anybody can be entered into a partnership business, can be entered as a partner in a partnership firm. So there is basically no sex discrimination. But when we talk about Hindu undivided family, only male members become partners by birth. Become members by birth. Female members have certain restrictions till date. Okay, still today there are many restrictions which are available for female members. Page number 183. Next it is number of members. If we talk about in a partnership firm, minimum number of member is 2 and maximum number of members are, if we talk about banking company, it is 10, and if we talk about other than banking companies, it's 50. Above 50 you'll not be able to appoint any partner. Okay, so the upper limit is 50 or 10. But when we talk about Hindu undivided family, there can be n number of members, that is there can be uh, any number of members. There is no restriction on numbers. Next difference is if we talk about authority. In a partnership firm, every partner has equal authority, can equally take part into all the decisions of a partnership business. But when we talk about Hindu undivided family, each and every member of the Hindu undivided family does not have a decision making power, does not have a power to actively participate into decision making. The ultimate decision making will be in the hands of Karta, that is the head of the family. Until and unless the head of the family approves your decision, till that you cannot take any kind of decision. If we talk about liability of the members in a partnership business, in a partnership firm, each and every member has unlimited liability, has a unlimited liability. Meaning of unlimited liability means that that partner is not just liable to the extent of the share of his profit or to the extent of the share of the capital he has bought. He will be personally liable for each and every conduct, for each and every debt. Like for example, I am a partner in a partnership firm. I have given a capital of rupees 1 crore, for example, and my share of profit is 50% in the partnership firm. Now, if this partnership firm becomes insolvent, or if this partnership firm, there is any kind of loss in this partnership firm, then I will be personally liable to the firm. That is not only till the extent of 1 crore that I have invested in the partnership firm. No, above from 1 crore, each and every property that is at my own name, that is my personal property, will also be liable to fulfill the losses, to fulfill the debts of the firm. Okay, so when we talk about partnership business, partnership firm, the liability of the members, liability of the partner is unlimited. It is unlimited. But when we talk about Hindu undivided family, only the liability of Karta is unlimited. Only the liability of Karta, that is head of the family, is unlimited. Rest remaining partners have limited liability, that is to the extent of the share of the profits or to the extent of the capital they have invested, like that. They are not personally liable, but the Karta is personally liable. Karta has unlimited liability. Next difference is, if we talk about right of member to share in profit. When we talk about partnership, each and every partner has a right to share profit equally or in the said ratio. Nobody could be denied, nobody could be left over. Okay, everybody will be sharing equal amount of profits or the ratio that has been decided. But when we talk about Hindu undivided family, there is no such right. If the Karta wants, then he can distribute the profits. If the Karta want, he can detain all the profit. He can keep all the profit. Okay, so there is no such, we can say here sharing of profit is not mandatory. But in a partnership firm, each and every partner has a right to share profit either equally or in the said ratio. If another difference is, if there is death of partner, if there is death of partner, then a partnership firm can be entirely dissolved. That is, partnerships come to an end. Or if there is no such provision, then the remaining partner can continue being the partners. But when we talk about Hindu undivided family, the co-partner of the Hindu undivided family, if there is death of any co-partner means the member. So if there is death of any co-partner, then in that case, Hindu undivided family will not be dissolved. Okay, it will not be dissolved. It will continue as it is. But in case of partnership, if a partner dies, a partnership firm can be dissolved. Next, so these are the basic differences between partnership firm and Hindu undivided family. There is one more concept which is known as co-ownership, Here also, people get confused that it is a partnership firm, but they are not partners. They are co-owners of a property. Now, for example, the house in which I'm living, this house belongs to me and my husband. So there are two owners of this property. When there are two or more than two owners of a property, then they are known as co-owners. Now, me and my husband will not be called as partnership here. Okay, we will be known as co-owners. So when we talk about co-ownership ka concept, it also seems similar like partnership, but it is not. It is different from a partnership firm. So let us discuss the basic differences between partnership and co-ownership. Firstly, partnership, again, it is created by agreement. It is created by agreement. But when we talk about co-ownership, here agreement is not necessary. If me and my husband are purchasing this property together, we are the joint owners, then we need not form any agreement between us. Okay, so here agreement is not mandatory. But when we talk about partnership, in a partnership firm, agreement is compulsory. If you want to enter into a partnership firm, you'll have to make an agreement beforehand. And that agreement is called as partnership deed, that we'll be discussing in the later sections. Second difference is when we talk about a partnership firm, they share profits and losses equally or in the said ratio. But no such profit sharing is necessary in co-ownership. Okay, co-owners are not entitled to share profits. If they want to, they can, but there is no such mandation. Okay, there is no such necessity that they have to do it. But when we talk about partnership firm, it is compulsory that they have to share profits or they have to share losses equally or in the said ratio. But there is no compulsion in case of co-ownership. Third difference is when we talk about partnership firms, partners are mutual agents of each another. Every partner acts as an agent of other partner. But when we talk about co-owner, there is uh, no such agent principal wala relationship between them. Okay, every co-owner is considered separate. Next, if we so there are many differences you can read on your own, very easy differences. Okay, so there are 7 kind of other differences between co-owners and partners. It is quite similar to the differences that we discussed of Hindu undivided family. Okay, that's why I'm leaving up to you that you'll read this. Okay, so next topic that we are starting here is types of partners. How many types of partners are there in a partnership firm? There are different kinds of partner in a partnership firm. There are 7 types of partner in a partnership firm. These 7 types of partners are: firstly, active partner. First kind of partner is active partner. Active partner is also known as actual partner or ostensible partner. Okay, question can straight away come like this, that what is an ostensible partner? So don't get confused. If we say active partner or if we say actual partner or we can say ostensible partner, all the three have the similar meanings. Okay, so don't get confused that what is an ostensible partner. So first kind of partner is active partner or actual partner or ostensible partner. What is an active partner? A partner, firstly, it is a partner who enters into a partnership firm via contract. That is, he is entered into a partnership firm by having a contract with the other partners. Okay, so he cannot enter like that only. Okay, yeah, I am the partner from today. No, firstly, these kind of partners enters with a contract, and secondly, this partner actively takes part in all the management of the business. That is, for example, if I came as a partner in a partnership firm, I signed a contract, I am acting as a mutual agent of other partners. I'm dealing with the clients. I'm dealing with the laborers of the firm. I'm dealing with everyone. I'm going to the third parties and getting contracts. So here what I'm doing, I'm actively participating in the management of the business. So such partners are known as actual partner. So when we talk about actual partner, you have to remember three things regarding actual partner. Firstly, active partner, sorry. Active partner is also called as actual partner and ostensible partner. Second, this partner enters with the help of a contract. This partner enters by contract in the firm. And lastly, this partner actively take participation in the management of the business. So these 3 points are regarding active partners. I hope active partner is clear. Let's move ahead. Second kind of partner is sleeping partner. Second kind of partner is sleeping partner. This partner is also called as doormat partner. This partner is also called as doormat partner. By the names, you must have got a hint that what kind of partner it is. Like the doormat kept outside our house. What is the use of that? Nothing. It is just kept there. Nobody bothers about that. Okay, right? So just like just like doormat, doormat partner is also a partner in a partnership firm who contributes the capital in the firm, who contributes capital in the firm, who shares profit and losses in the firm, but do not actively take participation in the management of the firm. Like for example, I am joining a partnership firm. Okay, I have contributed capital. Even I have decided my share in profit and losses, but I am doing nothing. I am doing nothing. I just contributed 1 crore rupees and I just stepped back, and I am not dealing with any customers. I'm not helping them in any kind of other works. I'm not acting as an agent to the other partners. So I will be known as sleeping partner or doormat partner. Um Here, just like other partners, this partner is also liable for everything. For everything means if the firm got dissolved, if the firm got insolvent, etc., he'll be also having same liabilities at the just like the other partners are having. No relief is given. That is, he's also having unlimited liability, etc., etc. All the other liabilities that active partner is having, that will be with the sleeping partner. And lastly, because his relationship with the firm, his name, his relationship with the firm is not disclosed with the other parties. Like if other partners are dealing with the other parties, with creditors, with purchasers, etc., in that case they'll not be using my name because I am a sleeping partner. Okay, so because my name is not used anywhere, so in case of retirement, if I get retired from this firm, I need not give a public notice. I need not give a public notice. Reason behind this is nobody was having knowledge that I am a partner here. Okay, except for sleeping partner, other partners, if they retire from the firm, they'll have to give notice prior to retirement that yes, my name is so and so, and I'm getting retired from this firm, and from today onwards I will not take part into any activities of the firm. I have taken all my profits, I have cleared all my liabilities, etc., etc. Such public notice will be issued by them. But in case of sleeping partner, no such notice is required because his name is also not disclosed. So dormant partner or sleeping partner, it is clear from the name itself that this partner is not actively taking part into any kind of business management, in any kind of business activities, but he brings capital, he shares profit, he shares losses, he is responsible, he is liable to other to every other activities, but his name is not disclosed to the general public. Okay, so this is a sleeping partner or doormat partner. Any doubt till here? Any doubt? Okay. Next kind of partner is nominal partner. Sometimes what happens na, a person is just used for his name. Okay. Now, for example, there is a famous person XYZ. Okay, he is very famous in his locality. Now, there is a partnership firm that we are having. We use the name of that person with his consent. Okay, we cannot use anybody's name without their consent. Now, we asked a favor from him that can we use your name as a partner in our business if you have any problem, if you don't have any problem. So in that case, here we can use that person's name in a partnership firm. That is, we can say that yes, XYZ is the partner here. So because of his name, because of his goodwill, other people will come to us, right? Nobody knows us, but everybody knows that person. So we are just using his name, and he's just lending his name to use to us for grabbing the people's attention. Okay, so this kind of partner who is just lending the name, who is neither sharing profit nor sharing any kind of losses, not participating in the business, not bringing any capital in the firm. Okay, so such partner is known as nominal partner. A nominal partner is a partner who neither shares capital nor shares profit, even does not share any kind of losses, and even do not participate in the activities of the partnership firm. He just lends his name to the firm to use his name. Okay, so this kind of partner is known as nominal partner. But one drawback of this partnership is that he cannot actively participate in our firm. He is not lending anything. But because we are using his name with the third person, we are using his name with the third parties, so he will be liable to the third parties. Now, for example, I purchased something, or I took a loan of rupees 1 crore from another person taking XYZ's name. He's not the partner. He's not the partner. He's just a nominal partner. That is, he has just lent the name for the firm. Okay. So here I am using his name that Mr. XYZ is also our partner. So please give loan of 1 crore. You know this person, he's a very renowned person. Now what will happen? Now this creditor has given me loan on the name of XYZ. So what is happening here is, in case if we, that is partners, fail to pay this loan, or if we become insolvent or something like that, then this XYZ will be equally liable, because he has this creditor has given us loan on his name. His name is being used constantly in the firm, so that is why we'll say that he will be that this nominal partner will be liable to the third parties, So I repeat, nominal partner is a partner who neither shares capital, who neither shares profit, nor he shares any kind of losses, and even he did not and even he don't participate in any kind of business management. He just lends his name to be used in our partnership business, but he is liable to the third parties. Next kind of partner we have is partner for profit. Here, like in the other partners that we have discussed, those partners shares profit and losses both of a partnership firm. But this partner, that is partner for profit, by name it is clear that this partner only shares profit, but he do not share any kind of losses. He do not share any kind of losses. Like for example, now in this year, our partnership business has gained 1 crore rupees as a profit. Okay, so if the share of the profit is equally distributed, then this partner will also get equal share of the profit. But for example, this year if there is a loss of rupees 50 lakhs, and it is said that profits losses will also be distributed among the partners equally. So here all the partners except for this partner for profit will be sharing the losses. This partner will not share any kind of loss, because this partner has been appointed just for share in profit. Okay, so firstly, not a partner for profit is a partner who has just been appointed in the firm for sharing of profits. There, that is, he'll not be sharing any kind of losses. Next, it is appointed by all the partners of the firm. Okay, so each and every partner must be agreed for such appointment, that yes, we agree that you can appoint XYZ as a partner for profit, that is, he'll be sharing profit. If any of the partner denies to do so, then this partner will not be appointed. So this partner, a partner for profit, will be appointed by unanimous agreement of all the partners. Okay, all the remaining partners. If they unanimously agree for the admission of this partner, then only this partner will enter into a partnership firm. Lastly, this partner, although he's just for profit, but just like other partners, he will also be liable to the third parties for debts, for anything. Okay, for all the management activities, etc. He'll be liable. Okay, so partner for profit is a person who is appointed in a partnership firm just for profit, but his appointment will be subjected to agreement of all the partners, unanimous agreement of all the other partners, all the remaining partners, and this partner will be liable to third parties for debts, for management, for purchasing, for selling, etc. Each and every kind of work. Okay, any doubt in these two? Or shall we move ahead? Okay, next type of partner we have is sub partner. Okay, if we talk about a sub partner, the name says that it is sub partner, that is partner ka partner. When a partner shares his share of profit with some other person, that other person is known as sub partner, Now, for example, in a partnership firm, I received rupees 1 lakh as my share of the profit. Now, what I did was I gave 50% of this share to the third person. Suppose my son. Okay, I gave this 50%, that is 50,000 to my son. Now I'm sharing 50% profits continuously with some other party who is not the partner of the firm. Here, this other party with whom I'm sharing my share of profit will be my sub partner, Now, this sub partner is not the partner of the firm. Firm का partner नहीं है वो. He is not the partner of the firm. He is just the partner of me because I am sharing my share. not firm share. I am sharing my share of profit with that another person. Okay. So he does not have any rights and liabilities regarding firm. He cannot actively take any kind of he cannot actively take any kind of decision in the partnership firm. He cannot actively participate in the management of partnership firm. So sub partner is a partner with whom the current partner shares losses. So he is his sub partner, not the partner of partnership firm. Okay. So here, if I'm sharing my share of profit with some other person who is not the partner of the firm, that other person will be known as my sub partner. Will be known as my sub partner. Remember one thing: this third person does not have any power, any existence in the partnership firm. That is, he is not the partner of the partnership firm. He is just my partner. Okay. So here, such person will be known as sub partner. So sub partner, the concept of sub partner is very easy, where you share your share of profit with some other people and with some other party, and that other party will be known as sub partner, and sub partner will not give any capital, will not share profit of the firm, will not share losses of the firm, will not take actively part into any activity of the firm, is not liable with any third party, is not having any right or liability in the partnership firm. Okay, so this is a sub partner. Next kind of partner is partner by estoppel. The meaning of word estoppel I have repeatedly told you. Okay, so the meaning of estoppel is stop from denying. Sometimes what happens now, a person is not a partner in a partnership firm, but he is just pretending to be the partner. That is, he's just using the name of a partnership firm. Now, for example, there is a partnership firm and I am not the member of that partnership firm. I am not the partner of this partnership firm, but I am just representing myself as the partner of that firm, and I am doing any kind of business activities relating to that firm. So here, actually, if we talk about reality, I am not the partner of that firm, but I am just representing myself. Now, later on, if I deny that no, I did not represented myself as the partner of this firm. So here, because to stop such denial, such kind of concept was made, that is partner for estoppel. Here, because I'm using partnership's name, the partnership business's name, then I'll be known as partner by estoppel. Okay. I am not appointed by any kind of contract. I am not appointed by unanimous decision. I am appointed by my conduct, because I have done something on the name of partnership firm. That is why I will be known as partner by estoppel. That is, later on, I cannot deny that I wasn't the partner of that firm. Now I will be the partner of this firm. Let's take an example of this partnership, this kind of partnership. For example, if a partner want to retire himself from the partnership firm, then he'll have to give a public notice that I, Megha Vyas, is retiring from so and so partnership firm. From today onwards, I will be not sharing any losses, not sharing any profits, etc. And I have no interest in this partnership firm. A public notice will be issued so that the people do not get confused that I am still the part of that partnership firm. Okay. So if a retiring partner do not give any public notice, still remaining partners are using his name in the partnership firm. He is also entering into contracts in the name of partnership firm. That is, he is not still given public notice. Then also this partner will be known as estoppel, partner by estoppel, because he is no more. He has been retired. He has been freed from all the duties of the partnership firm, but yet he is using his name, or the other partners are using his name, then he will be known as partner by estoppel. Here, this partner will be responsible with third party. He'll be liable to the third party because his name is still being used. Okay, but this estoppel wala concept is not applicable on the deceased partner. That is, if a partner dies and then you are using his names, you are still using his name, then it is not correct. You can, there can be criminal activity against you. Okay, so if a partner is retired, then you can use that person as a partner by estoppel. But if a person dies, this concept is not applicable. So a partner by estoppel is a partner who is not appointed by any kind of contract, any kind of deed, any other concept, but he is just appointed because of his conduct, because of the activities he has done in the partnership business. Okay, so this is partner by estoppel. In case of any loss, the sub partner cannot be responsible, because sub partner is partner sub partner but not the partner of the firm. So in case of any loss, only the partner will be responsible. It is up to him. Like I gave my share to my son, so now if there is loss and I'm facing any loss, it is my discretion. If I want to take that loss from that my son, I can take that, but if I don't want, I cannot. Okay, so it depends on the partner that he want to take share from the sub partner or not. But for, if we talk about partnership firm cannot demand any share of loss from that sub partner. Okay, last kind of partner we have is minor partner. Okay, a minor, just remember one thing. Firstly, a minor can never be a partner in a partnership firm. A minor can never be a partner in a partnership firm. But a minor can be appointed. Excuse me. A minor can be appointed for sharing the benefits. That is, if you are appointing a minor person just to share benefits, that is just to share the profits of the firm, you can appoint minor. Okay, but generally minor cannot be a partner. Minor can be a beneficiary in a partnership business. Minor cannot be a partner, but minor can be a beneficiary. देखो, सब partner वाला concept is a quite different concept. We are not appointing that person as a partner. Sub partner means that, like for example, I am the partner of the firm. Okay, if I am sharing my share of profit with somebody else, that will be my sub partner. Okay, so that sub partner is nowhere related to the firm, that is, if there is loss, if there is bringing capital, etc., in any kind of concept, this sub partner will not held responsible. It is just a simple concept that I am the partner of the firm, I am the legal partner of the firm, and I am receiving some share as a profit. I am entitled to receive. Now, this share that I have received, I am sharing this profit with somebody else out of love and affection, out of something else, out of agreement. Anything could be there. Any reason could be there. So if I'm sharing this profit with some other person, that is my personal profit, not the firm's profit. If I'm sharing my personal profit with some other people, that will be known as sub partner. Okay, this partner will be nowhere related to the partnership firm. That is, he will not take any kind of interest, any kind of involvement in the partnership firm. Clear? So this is this sub partner is partner's partner, not the partnership's partner. Okay, I am partnership's partner. That is, I am the partner of that firm. But this XYZ, I am just sharing profit with this XYZ. he is not the partner of the business. He is my partner. Okay. So I and him will be called as sub partners. So this XYZ is my sub partner, not partnerships firm. Okay. Clear? We don't appoint them. We just okay, give our share कि चलो तुम खुश रहो. Okay, like that. He is not anywhere related to the partnership firm. This is just an imaginary concept. Nobody gives a share of profit to anybody else. Okay, so practically this could be some other scenario, but it is just theoretical. Okay, so minor, I was talking about minor. So minor cannot be a partner in a partnership firm. Minor can only be appointed for the benefits. You'll have to make sure that if you are appointing any minor in a partnership business, then each and every partner should agree to it. Like for example, I want to appoint my son as a partner in this firm and he is minor. He has not attained the age of 18 years. So in that firm, suppose that we are 4 partners. So I will have to take permission from all the 4 partners. If any one of the partner denies, then this minor cannot be appointed for benefits. Okay. If you want to appoint minor as a beneficiary in a partnership firm, then you'll have to make sure that the consent of each and every partner is required. That is unanimous consent is required for appointing minor as a beneficiary. So if a question arises in your exam that can a minor be appointed in a partnership, can a minor be appointed as a partner in a partnership firm? Answer is no. A minor can never be appointed as a partner in a partnership firm, but minor can be a beneficiary in a partnership firm, and that too with unanimous consent of all the other partners. Okay, so if a minor is there, if we have appointed a minor who is a beneficiary of the firm, then in that case this minor will have certain rights, duties and liabilities. What are these rights and duties? Firstly, we'll have to give share of profit to that minor also, but we cannot demand anything from him if there is a situation of loss. Okay, so if there is a loss, we cannot demand anything, a single penny from that minor. But if there is profit, we'll have to share whatever share that we have decided to give that minor, we'll have to share that loss. Secondly, he will not take any participation in the conduct of the business. That is, minor will not do anything for the firm, will not actively take participation in any uh, business activity. Third right that a minor have is minor can inspect all the books of accounts. Okay, now if this minor wants to check the book of accounts, he can. If he has a knowledge of accounts, then he can check the books, he can inspect the books. He can also demand a copy of books. Okay, so a minor can check, inspect or demand copy of books of accounts of the firm. Fourth, a minor has a right to sue the firm for his name if the partnership firm disagree to give his share of profit. Now, for example, my son is a minor who has been appointed in this partnership firm as a beneficiary. Now, every year, whenever there is a profit, we give 10% of profit to this minor. Now this year we haven't given any profit. There was profit. There was a sufficient amount of profit, but still we did not give this share to this minor. So here the minor, although he's a minor, but still he has a right to file a case against us, against the partnership firm. So a minor can sue the other partners on his own name. Lastly, there is one more right available to the minor, that when he'll become major, when he'll become a major, he'll attain majority. At that time, if he want to continue in this partnership firm, if he still want to be the partner So now he can be appointed as a partner. There is no such rule that if the minor become major, then he cannot be appointed. No. If the minor attains the age of majority and if the other partners agree and if he is willing to enter into the firm as a partner, then he can be appointed as a partner in this firm. Sue means filing a case. Sue means filing a case. Like I said, I will sue you. That means what? I will file a case against you. Okay. So these are certain rights that a minor have in a partnership firm. Similarly, there are certain liabilities also. That is, firstly, a minor cannot be declared insolvent. Why? Because we are not taking anything from the minor. He is just there for profit. He's just receiving. He's not giving anything. If you're not giving anything, then you cannot be an insolvent. Okay. So here, minor can never be insolvent. Plus, minor is liable only to the extent of the share of profit. After that, he cannot be personally liable to the third parties. He is not liable to the third parties. We can question that minor only till the share we are giving him. Okay, but after that, if we are dealing with the third parties, etc., those third party cannot help, cannot. Sorry, this minor will not be personally liable to those third parties to other partners. Okay, so minors are just for sharing profit purpose. They are not personally liable for any kind of things. Okay, so these are certain liabilities that you can read on page number 186 of your book. Okay, so these are certain rights and liabilities that a minor partner have. So the topic we completed is types of partner. There are 7 kind of partners in a partnership firm. One is active partner, sleeping partner, nominal partner, partner for profit, sub partner, partner by estoppel, and minor partner. Okay, so there are 7 types of partner in a partnership firm. Next is registration of a partnership firm. Any doubt till here in the topic types of partners? Okay, next is registration. If we talk about a partnership business, the easiest, the simplest kind of business is partnership business, which have minimalistic formalities to follow. If you want to get your partnership firm registered, firstly, registration is not mandatory. If you are doing any partnership business, then there it is not necessary that you will have to go to the registrar of the area and get your partnership registered. It is not necessary. It is not mandatory. It is optional. If you want to, you can get your partnership firm registered. So, firstly, registration is not necessary. Second, if you want to get your partnership registered, only thing you have to do is you have to go to the registrar of the nearby area, wherever the place of business you have. You'll have to go to that area. You'll have to give the name, address, etc. of your partners and get your details registered in the register of the registrar of firms. Registrar of firms. Along with these necessities, you'll have to fill certain forms which are required. Now, I'll not be discussing. There are many forms that you'll have to fill. Form number something, that etc. I'm not discussing those forms because that forms are not part of your course. Okay. So if you want to get your partnership firm registered, you'll just have to go to the nearest registrar of firm of the area where your business is there, not the area of your residence. Okay, so for example, if I am living in Jodhpur, So I'll not go to Jaipur, or I'll not go to any other place to get my firm registered. I am living in Jodhpur. I'm having my business in Jodhpur. We are having a partnership firm in Jodhpur. So I'll get my partnership registered with the nearest registrar, which is there at our business place. Okay. So you'll have to get your business registered. You'll have to get your firm registered with the nearest registrar. You'll have to go there. You'll have to ask them to enter all the details in their register. Okay, the register that is maintained by the registrar of firms. You'll tell each and every detail, that is the name of the partnership firm, the name of the partners, the address of your business, the address of the partners, the nature of the business, etc. All the details you'll be telling to that registrar of the firm. You'll get that firm, they'll issue a certificate. Okay, and that certificate means that now your firm is registered. Now your firm is registered. Now this registration certificate just acts as a proof of existence. Okay, now this registration firm does not create the partnership. Partnership is created by the partners, but partnership is still in existence. It can be proved by the registration letter. Okay, so just make sure that firstly registration is not mandatory, but if you do not get your firm registered, then you will be facing certain issues in future. Okay, like you cannot sue in your name, or there are many issues that you'll be facing that we'll be discussing in the later on sections. Okay, so this is the process of registration. Registration is not mandatory. I'm repeating in again and again. Reason behind is a question straight away can come into your exam, that is registration mandatory in a partnership firm. Then you'll think that, yeah, if you are opening some partnership firm, then you'll have to get it registered. No, registration is not mandatory, but it has certain restrictions if your firm is not registered. Registration will be best proof of partnership, so it is advised that you should get your partnership firm registered, but it is not mandatory. If you want to get your firm registered, you just have to do is you have to go to the nearest registrar of the firm, which is nearby your business place, and you'll have to get everything registered there. Okay, so these are certain formalities that you have to fulfill if you want to get your firm registered. Any doubt till here? So the first concept in registration was procedure of registration, that we have already discussed. Second concept is partnership deed. I am not discussing it today because this is a very vast topic. We'll be doing this day after. So till this topic, if you have any doubts, you can ask me here, or you can leave the class. Okay, so that's it for today. We have discussed three things today. One is difference between partnership firm and other kind of businesses. Second, we have discussed type of partners, and third, we have discussed the registration procedure of a partnership firm. Any doubt till here? If you don't have any doubt, you can just leave the class. Okay. I hope everything is clear. Whatever we uh, gone through, whatever we have gone through today, I just advise you to read each and every topic that we have done, because if you skip reading, then हो सकता है there are such topics which I forget to discuss in the class, or which I might have skipped by mistake. Okay, generally I do not skip, but human error could be there. Okay, so I expect that you all are reading each and every topic that is discussed in the class every day. Okay, because it is very necessary, because all the doubts are cleared then there itself. Okay, so try to read your modules daily. I like you asking doubts, because asking doubt is a proof that yes, you were attentively listening to whatever bakwas I was doing. Okay, so just keep on asking doubts. Just don't hesitate while asking doubt, because everyone are on the same page here. Okay, nobody is superior, nobody is subordinate. Okay, so don't hesitate in asking any kind of doubts. You can ask any kind of doubts relating to this topic, and once I complete the class, you can ask doubts relating to the other topics also that we have discussed. Okay, so do not hesitate to discuss anything. Okay, that's all for today. Bye bye everyone.